How this meeting by staying this.
Your microphone is open.
Okay. All right, we ready?
The state of Michigan City of Detroit, 36th District is now in session. The Honorable Judge Aliyah Sabree presiding. Good morning, Your Honor.
Good morning, everybody. Two of our clients were cut and I put them in the waiting room. You have to wait a moment. Okay, Roger White. No problem.
Ready, Your Honor.
Ms. White?
Yes.
Okay, this is case 2356129, people of the state of Michigan versus Roger White. Ms. White is charged with one count of assault with a dangerous weapon. Is assault set for a probable cause conference today. Appearances?
Alexander Kruger on behalf of the people, P86282.
Your Honor, may it please this honorable court, Larry Polk on behalf of Raja White, who is present, gives her permission and consent to have this hearing by way of Zoom. Ms. White, would you state your name for the record, please?
Raja White.
Sabree?
Yes, I have the discovery, Judge, and we're requesting an exam date.
Okay. I have 26, 27, and 28 open as earliest dates.
Okay, what time would it be on the 27th, Judge?
I have 9, 9:30, 10:30, 11.
Can we do, let me see. And I apologize, can we go back to the 26th, the earliest time that you have on the 26th?
9:30?
That'll be fine, Judge.
Okay. All right, so it's set for April 26th at 9:30 in person. You understand that, Ms. White?
Yes.
Okay, anything else?
Nothing else, Judge. Thank you. You and your staff have a great day.
As well, thank you. Attorney Richard,
Thank you.
and all the attorneys looking for an exam date, the dates we have available are the earliest dates right now are 26, 27, and 28. So if you want to check your calendar, so we call the case, we'll be ready to set a date. I would appreciate it.
Okay.
Attorney Richards, who?
I have Washington Clark.
Okay.
He is not present. I'm asking to waive his presence.
Okay. 2356008, people of the state of Michigan versus Clark Washington Jr., who was charged with one count of controlled substances, possession, cocaine, heroin, or another narcotic.
Do it.
Set for a probable cause conference. So the person who keeps talking and cussing while we're on the record, please stop. Appearances?
Alexander Kruger on behalf of the people, P86282.
Good morning, Your Honor. Neighborhood Defender Service of Detroit by Nancy Richards, P68850, appearing on behalf of Mr. Clark. Actually, his name is Washington Clark, not Clark Washington. I have had a chance to talk with him. He's not good at Zoom, so I am asking to waive his presence for today.
Okay, and you've been in contact with him?
Yes,
Okay, you have discovery?
I do.
Okay, you ready to set a date?
Yes, the 26th of this month is a good date.
Okay, does 10:30 or 11 work for you?
Either one.
Let's do 10:30.
Okay.
All right, so April 26th at 10:30 for the exam. Anything else?
Oh, Your Honor, thank you.
You're welcome. Have a good day.
Thank you.
Timothy Williams. Okay, anybody ready on their case?
I am,
Yes,
Your
Your
Honor.
Honor.
City on
Richard
McLaughlin,
Glenda,
Judge.
Gene Gibson.
Okay, Landis or anything, Mark? Okay, Leonard McLaughlin. Case 2259014, the people of the state of Michigan versus Leonard Norrell McLaughlin, who was charged with count 1 and count 2, police officer assaulting, resisting, and obstructing, and count 3 and 4 assault or assault and battery set for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P 86282.
I'm Zaranick for Mr. McLaughlin, Your Honor, P 39346. Mr. McLaughlin, can you state your name, sir?
Leonard McLaughlin.
Okay, and
Good.
attorney discovery.
We did get some discovery, Judge. I just got some more over the weekend. I haven't gone over it with the defendant yet. Just wondering if we could have a week or two.
Okay, can we also set the exam date with the PCC adjourned?
Okay,
Okay, so I will, another PCC for the 17th at 8:30. And then, I still have a couple of times at the 20, on the 26th, and then the 27th, and 28th open.
probably the 28th, Judge, I guess.
Okay, how about 9 o'clock?
Perfect.
Okay, all right, so I will see you all on the 17th for another piece, 8:30.
Sounds good. Thank you, Your Honor.
Have a good day, both of you.
You too. Thanks. Bye-bye.
Bye. Attorney Martin,
Good morning, Judge.
Martin, who is your client?
Mr. Looney, Nicholas Looney.
And Glenda, you have,
Gene Gibson, Judge. Gene Gibson. I'll waive her appearance. She's having some technical issues.
okay, I'll start with Looney. This is case 2356205, the people of the state of Michigan versus Nicholas Chase Looney. One count of stolen property, receiving and concealing a motor vehicle set for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P 86282.
And good morning, Neighborhood Defender Service of Detroit, Harry Martin, P 84592, appearing on behalf of Mr. Nicholas Looney. Mr. Looney, please state your full name for the record.
Nicholas Chase.
Thank
Say that
you.
one more time, Mr. Looney.
Nicholas Chase Looney.
Thank you. Okay, Attorney Martin, do you have discovery?
I do have both digital and paper discovery. I'm ready to set this for exam. The 26th would be a good date for me.
Okay, I have 11 o'clock open.
That's perfect. Thank you.
Okay, anything else?
Nothing. Thank you, Judge.
You're welcome. Have a good day.
Mr. Looney, I'll talk to you before then.
Okay.
All right, bye.
Everybody.
Okay, this is case 23056168. People of the state of Michigan versus Gene Gibson, who's charged with one count of weapons carrying concealed set for a probable cause conference.
Alexander Kirkland, on behalf of the people, P86282.
Good morning, Judge. Richard Glenda, 32990 for Ms. Gibson. If she's not on the call, ma'am, I'll waive her appearance. She's having some tech issues, perhaps.
Okay, and you've been in contact with her?
I have, Judge, yes, a number of times.
Okay, all right, you have discovery?
Yes, ma'am.
Okay, ready for a date?
Right. The only date is available is the 26th. I don't know if you have any openings left, but the 27th, 28th are totally booked.
I have 11:30 left on the 26th.
That's fine. Thank you.
Okay, so it'll be set for April 26th at 11:30. Anything else?
That's it. Thank you, ma'am.
You want to have a good day? Okay, any other attorneys ready?
Yes, I am ready, Your Honor.
Quinn is ready on Deshaun Rice.
And I'm ready on Winston.
All right, let's talk Quinn. Howard Winston, case 2258781, the people of the state of Michigan versus Howard Winston, charged with. One moment here. One count of stolen property, receiving and concealing of motor vehicle. Set for, I believe, a competency hearing today. Yes, appearances.
Alexander Kirkland, on behalf of the people, P86282.
And good morning, Your Honor. Janet Spahn, P43281, appearing on behalf of Mr. Winston.
Okay, and did you receive reports from the forensic center?
I did, Your Honor. This is actually an adjourned competency hearing. This was up a couple weeks ago. Based on the findings in the report, I made a motion to dismiss, and the prosecutor asked for time to review it. And I would just renew that motion at this time. He has severe cognitive limitations. It's not a psychiatric issue. And the forensic doctor opined that he cannot be restored to competency.
Mr. Kirker, are you familiar with this case?
I don't believe so. Not sure if I was here perhaps, I don't believe I was.
Attorney Spahn, do you remember who you talked to in the prosecutor's office?
I'm sorry, what was your question, Your Honor?
Do you remember who you spoke to in the prosecutor's office who requested more time?
I don't, Your Honor. I know it was a female, and I know Judge King was standing in for you.
Okay. Ms. Kirker, how do you want to move forward?
Oh, wait a minute. Maybe I have it here. Perrick is her last name.
Ms. Perry, okay.
Yeah, so I'm just looking at the notes now. I do not have the authority to just dismiss it at this stage. I will leave it to the discretion of the court.
So do you know why Ms. Perry asked for more time to consider the dismissal?
Probably to ask about whether we can dismiss this case or not.
I'm gonna recall.
Yeah, she said the same thing, Your Honor, that she did not have authority.
Okay, well, I'm dismissing without prejudice.
Thank you, Your Honor.
You're welcome.
I appreciate it.
You're welcome. Anything else?
Do I need to submit an order or?
I will fill out the order and have it sent to you and to everybody.
All right, wonderful. Thank you, Your Honor. Have a great day.
You too. Thank you. Attorney Upshaw, who are you here for today?
Terrence Williams.
Terrence Williams.
I think that's him on the screen in the Wayne County Jail.
Okay, are you going to be handling this case all the way through to the exam date?
Yes, I am, Your Honor.
Okay, if you give me a moment, I'm going to disqualify my case from myself from this case and send it to another courtroom. Let's see here. Attorney Upshaw, I'm going to put you in a breakout room with the court. I have a question.
Yes, Your Honor. Okay.
Let's try this again.
Mr. Williams,
Yes.
I've been trying to reach you. I put my number in the chat. You want to call me? This is your lawyer.
Okay. Yep. How's it going?
248.
Oh, give me 1 second. 248.
Or give me your.
Yep.
Give me your number.
313. Oh no, it's 58310.
I can't hear. 586. Your number?
Okay, we're back on, we're on the record on Terrence Williams, 2356199. Mr. Williams is charged with one count of robbery armed. I stated briefly that I would have to disqualify after speaking sidebar with prosecutor present and Attorney Upshaw. I withdraw that statement. Appearances for the record, please.
Alexander Kruger on behalf of the people, P86282.
Randall Upshaw, P number 43574, on behalf of Mr. Williams.
Mr. Williams, please use your device and state your name, please. Mr. Williams, can you state your name, please?
Yep.
No, Terrence Williams.
Williams the second.
Oh, Terrence Williams, excuse me. Terrence Navarre Williams, can you state your name?
Yes, Terrence Navarre Williams the second.
Okay. Do you have discovery?
I do have discovery, Your Honor, and I am available on the 27th for the case, Your Honor, but I would just like to address the issue of bond, if I may.
Okay.
Your Honor, I've read the discovery, and the discovery on this fact supported the argument that the police alleged that Mr. Williams was out going to smoke some marijuana with a female friend, and she claimed she didn't know his address. 10 days later, he was driving down the street going to a party with the same victim. They were having a good time. Police put him over for speeding and would say, "Oh, it's a warrant for your arrest." Arrested him and told the victim to go home. They have been constantly associating all this time. It was a boyfriend, girlfriend part where she was mad. Never seen somebody that alleged a robbery. And then when the police pulled the defendant over 10 days later, she's a passenger dressed up and they're going out on a date again. Your Honor, he's been in jail since the date of this incident. I would ask the court to consider a $5,000, $5,000 cash or 5,010%. On this case, based on these unique facts. The victim is still calling, going them out, and the police are evidence. If you look in the police report, you will see she was with him on another date about 10 days later.
Anything from the people?
I'd have to review the police report for that fact, but just given the nature of these charges, we would ask for bonds to remain the same, or if there are any changes to for no contact with the victim.
Judge, I would think he would just take a quick look at the police report, and it's undisputed. And I'm not going to jeopardize my career on behalf of making a police report that's not in existence. There was no guns, no violence, no acts. She claimed she took his pictures because she was mad at him for doing something with another girl. That's our opinion. But however, she was still with him when he was arrested 10 days later. No violence.
Okay, Attorney Upshaw, I don't even have a file to even look at anything right now. What, if you would like, at the end of the morning, you can come back and address bond, or I don't know what time we can schedule Division 2 to come back on, or we don't need him, we can waive his presence, but I don't have a file, and I would either like to or have a file or something to address this. I don't even know. I can't make a decision based off of not having the information.
Judge, I totally understand, and I will waive his appearance. Is it all right, Mr. Williams, if I come back without you?
Yes, sir.
Your Honor, I'll come back at the end of the docket And just tell me a time and I'll waive Mr. Terrence Williams' appearance.
Okay, let's do 11:30. We should have a file by then. Do you want to set an exam date now?
Yes, please.
Okay. Since he's in custody, I can try to squeeze him in the afternoon time, if you would like that, but it's a little bit earlier than the 26th.
Oh, well, the 26th. I can do the 26th, but I'm available on any day, 26th or the 27th, Your Honor.
Okay. How about the 27th at 10 o'clock?
Yes, Your Honor.
Okay. And then come back at 11:30. I should have a file and can make a better decision.
Thank you again. I'll see you then. Have a good day, Your Honor.
Thank you. Attorney Arm, were you trying to speak to Mr. Williams?
Yes,
Did you speak to him in the breakout room?
I would like to, but I don't see him on the screen now, but that would be great if he's here.
He's in the breakout room, in room 1.
Room 1?
Yep. Attorney Quinn?
Yes, I'm here.
Case 2259230. People of the State of Michigan versus Jermaine Allen Phimister, charged with count 1, weapons, firearms, possession by a felon, count 2, weapons carrying concealed, count 3, controlled substance possession, cocaine, heroin, or another narcotic less than 25 grams, counts 4 and 5, weapons, felony firearms. The habitual report defense notice is set for a competency hearing. Appearances?
Alexander, 86282.
Mr. Femster is another client of mine. I'm here on, I can address Mr. Femster, but I'm also here on Deshaun Rice. But if the court would like to address Mr. Femster first, I can.
Yes, and then we'll do right.
Excuse me, Judge.
Yes, if we could address Mr. Phimister.
I haven't gotten his competency review back. Does the court have it?
I have one dated, this was a Judge Stanford Jones case, so it was transferred over here. I have a report from the 30th of January. Let's see the last time here. I think the last time this case was heard was on January 9th. So this is, it says here that his competent to stand trial. Yes, he's competent to stand trial. Yes.
Okay, I guess I'll, if he's competent to stand trial, we can just set it for an exam. If I can waive his appearance.
Okay. All right, do you have discovery, or I know you weren't prepared for this one to be called first. Do you have discovery on this case?
No, if they could resend the link, and if if we can get a PCC date and an exam date, there's been some time to pass.
Okay. So we can come back on the 18th for a PCC.
Let me check that date. Yes, I'm available that day.
And then we can set exam date. Do you have anything open on the 27th or 28th?
The 28th at 10:30. If I could do like a 10:30 and 11. Mr. Rice would like an exam too.
Okay, do you want the same day for Rice?
Yes.
Okay, so I'll do 10:30 for Phimister, and then we'll do 11 for Rice. Once I call it out.
Okay.
All right. 10:30 for exam, and come back on the 18th at 9 o'clock for another, or for a PCC.
Okay.
Anything from the people on that case?
Nothing from the people.
Okay, now to Darshawn Rice, 2356112, people of the state of Michigan versus Darshawn Rice.
Christopher Quinn, P694883, appearing on behalf of Mr. Rice, who's appearing via Zoom and consents to appearing via Zoom.
Alexander Cooper on behalf of the people, P86282.
And Mr. Darshawn Quentin Rice is charged, count one, assault with intent to great bodily harm, less than murder or by strangulation. Count two, assault with dangerous weapons, felonious assault. Count 3 and 4, weapons, felony firearms, set for a probable cause. Any issues with discovery, Attorney Quinn?
No, I have the discovery at this time. I would just ask for an exam.
Okay, and he said the 28th at 11 o'clock, correct?
Yes.
Okay, anything else?
No, Judge. Thank you.
Have a good day. Attorney Barron?
Yes, I'm here on Kimoni Harris's case.
On the 26th or 27th.
Calling case 2355971, the people of the state of Michigan versus Kimani Harris, who was charged with one count of weapons carrying concealed for probable cause. Count for today appearances.
Alexander Cooper on behalf of the people, P86282.
Good morning, Judge Hannah Barron, P85265, representing Mr. Harris.
Mr. Harris, can you state your full name for the record, please?
Kimani Armand Harris.
Okay, you have discovery, Attorney Barron?
Yes, I do, Judge. So we just be asking for a preliminary exam date.
Okay. Did you hear the dates that I offered?
I didn't, I'm sorry.
27 and 28 are the earliest dates.
Okay, the 27th works for me.
27?
The 27th at 11 or later would work for me.
Okay, 27th at 11.
Okay, thank you.
Okay. Imani Harris, you still there? Imani Harris.
Yes, I'm still here.
Okay, your exam has been set for an in-person preliminary examination on the 27th at 11 a.m. Do you understand that?
11 a.m. You said in person?
In person at 36th District Court.
Okay.
Talk to your lawyer if you have any questions about the logistics of getting here or whether you're supposed to be in person, if you forget. But you are to be in person at 36th District Court on time, okay?
Okay.
All right, you're all set. You're all set, Attorney Barron.
Everybody on Timothy Williams?
The people of the state of Michigan versus Timothy Williams, case 2356202. Williams is charged with count 1, weapons, firearms, possession by a felon. Count 2, weapons, felony firearm. Count 3, weapons, ammunition, possession by a felon. Count 4, weapons, felony firearm. Count 5, weapons carried concealed with an habitual offender. Second offense notice set for a PCC today. Appearances.
Alexander Cooper on behalf of the people, P86282.
Daniel Iron, P61807 for Mr. Williams.
Mr. Williams, can you state your full name, please?
Timothy Sean Williams.
Okay, Attorney Arm, do you have discovery?
Yes, I do, Judge. Judge, we're prepared to waive the exam. I explained to him his right to have the exam and the standard thereof and prepared to waive it.
Okay, any objection from the people?
No objection, Your Honor.
Okay, Mr. Williams, I'm going to ask you a series of questions. If you don't understand me or if you can't hear me, please let me know and I will repeat the question, okay?
Okay.
Is it your wish to waive your preliminary exam today?
Excuse
Is it your wish to waive your preliminary exam today?
Yes.
Do you understand you have a right to a preliminary exam?
Yes.
And that if you were to demand an exam, the people would have to show at the probable cause standard, which is a much lower standard, but still a standard in criminal law. They will have to show at that standard, the charges that were read off, the 5 different charges were committed in the city of Detroit and that you probably committed those crimes. Do you understand that?
Yes.
And then by waiving your exam today, that means that the people at this stage, at the probable cause stage, do not have to show any evidence. Do you understand that?
Yes.
And I also let people know, you understand you're not giving up your right to trial.
I didn't hear that last one.
Do you understand that you are not giving up your right to trial?
Oh, yes.
Okay. Did anyone force you or threaten you to waive your exam?
No.
Anyone promise you anything?
No.
Okay, I find your waiver to be freely, understandingly, and voluntarily given. I will have you bound over for an arraignment on the information at Frank Murphy Hall of Justice. Your date will be April 24th at 9 a.m. That's 2 weeks from today. Do I have your permission, Attorney Arm and Mr. Williams, to sign your signature on the waiver form since you're not in person?
And what time was that on the 24th?
9 o'clock.
9 o'clock. Is it I have to go down to Frank Murphy, or is it like Zoom like this?
I don't know. You're gonna have to check with Attorney Arm once he figures that out. I don't know what they're doing for.
Okay.
So I didn't hear either of you all answer as far as signatures. Do I have your permission to sign?
Yes.
Yes.
Okay. All right. Anything else from either party?
Nothing
Nothing.
further.
Okay, you're all set. You all have a good day.
Thanks. Oh, good.
Attorney Elder? You're all set, Mr. Williams.
Good morning. I'm here on LT Christopherfield.
Okay.
Judge, I've had no contact with him. The information I have on the appointment sheet, I called to no success whatsoever. So I'm not sure what the court wants to do. I'm not sure if he's in custody or not.
It's actually custody on the file, but I'm not sure. Let's see here.
Judge, I checked Mr. Epps, he said he's not in custody.
Not in custody. Okay. All right. Do you want a week to find them?
Yes, let's do that, Judge. That's okay. I can mail a letter.
2259704, the people of the state of Michigan versus LT Chesterfield Jr., who is charged with one count of motor vehicle unlawful driving away with an habitual offender, fourth offense. Notice separate probable cause.
Alexander Kruger on behalf of the people, P86282.
Good morning, to your staff and attendants. The Ray Elder, on behalf of Mr. Christopherfield. My P number is 57728.
Okay. Attorney Elder, I know I just offered you a week to find your client, but I'm looking at the register of actions. He has a history of capious, and he capious on the 22nd of September last year, January 5th of this year before me. I don't believe he will show up. I am not confident that he will appear. You've had no contact with him?
No, Judge, the number I have, it's my notes say it,
It's the 586 number?
it won't dial. Yes, it's a 586. The number I have is 586-277-2279. So when you dial it, nothing happens.
I have 227.
227?
Yeah,
Maybe that's why. The last two or the first three?
the first three, I have 586-227-2279.
Maybe that may be the problem. 2279. You want to give me a second? I can try calling it.
Yeah, sure, or we can adjourn until tomorrow if you want, or either way.
That's fine. Tomorrow's fine.
Okay, so let's put it over till tomorrow because of the wrong phone number.
All right, thank you, Judge.
You've been out there. I already know.
I can't. Okay, Attorney Elder, he's an MDOC.
I'm sorry, Judge?
He's in MDOC. He's locked up.
Ah, I see. Okay. That explains it.
Yes, it does. All right, so we'll send a Zoom writ to have him appear. How much time do you need?
Will keep the rate, is he
Zoom writ? MBOC.
he's 7 days at least?
All right, let's do, can you do the 18th?
Judge, yes, I'll figure it out. I'm in trial the 17th, but yeah, let's do the 18th.
Okay. We'll send it over so it'll be on Zoom.
Thank you, Judge. Judge, do you have his, I think it may be, he has another case. I'm not sure if it's in front of you or not. On 13th.
On what day?
13th.
13th.
Yep, it's scheduled in front of you. So I'll come back on that one on the 13th then. What the case number?
I have the docket up, I don't see him on here. Yeah, oh, I see him, yep. Okay, narcotics. We can't get it with that fast.
It might be pushing in your honor.
So what we'll do, we'll try to send a writ over and see if MDOC will get him on the 13th. And if he happens to appear, I'll call that case as well, but I'm still gonna have to schedule it for the 18th because they usually do it for a week.
Got it. Thank you.
Okay, I will see you on the 13th.
Have a great day.
You too, thanks. Okay. So the gentleman, who was cussing and speaking over me on the record, what's your name?
Jean Gibson.
Your attorney already handled your case.
I didn't know that, ma'am. I couldn't hear anything.
Well, we can hear you cussing, so I put you into a waiting room because you were disturbing the court.
I apologize.
So, let's see.
I didn't know. This is not my phone. I'm just trying to, this is my first time ever doing Zoom.
That doesn't explain you cussing, but, so Ms. Gibson, your, case is scheduled for April 26th at 11:30 for an in-person preliminary exam.
Yes, ma'am.
Do you know who your attorney is?
Mr. Richard?
Yes, call him for the details, okay?
Yes, ma'am.
All right, you're all set.
Thank you, ma'am.
Well, the gentleman with the Samsung phone and the locks, can you unmute your device?
Yes, my name is LaFair Baldwin.
Say that one more time.
Excuse me.
Say your name one more time, I couldn't hear you.
My name is LaFair Baldwin.
You saying fair judge? I'm sorry.
LaFair. LaFair.
Spell it. LaFair, can you spell that, please?
LaThair.
Sir, what type of case do you have, Mr. Baldwin?
It's a traffic court case. I'm supposed to be in front of Judge Yancey.
Disconnect from Judge, excuse me, you need to disconnect from Judge Sabree's criminal courtroom and connect to Judge Yancey's traffic courtroom. That number, are you ready for it?
Yes.
It's 360-335.
335.
0000, and that's Judge Yancey's courtroom, okay?
Okay, thank you.
Welcome.
Thank you. Sorry for the delay. Mr. Reed, you are checked in. Your attorney is not present yet. When your attorney checks in, I'll call your case. If you want to call Attorney Diallo, please feel free to do so. I have you checked in. When she gets here, I'll call your matter.
Yes, ma'am.
Okay. You're on the record. This is people of the state of Michigan versus Antoine Davis, case 2258213. Mr. Davis is charged with count 1, controlled substance delivery manufacturer, schedules 1, 2, and 3, except marijuana, methamphetamine, ecstasy, and cocaine. And count 2, controlled substance delivery manufacturer, schedule 4, set for preliminary examination to appearances.
Alexander Kirker on behalf of the people, P86282.
And good morning, Your Honor. James O'Donnell, P42585. I'm here on behalf of Mr. Antoine Derek Davis. Mr. Davis, could you give the judge your name? Antoine Derek Davis.
Good morning to everybody. Okay, are all parties ready to proceed?
People are not at this time, Your Honor. The necessary witnesses have failed to appear.
Judge, I move for dismissal.
Okay, and if we're not ready to proceed, I will dismiss without prejudice. I have forms, I'm signing right now, shall it take, so thank you to waive the court.
Thank you, Judge. I'll be outside if I can get a copy of it, give you my client.
Okay.
Thank you.
Yeah.
All right, this is case 2355205, the people of the state of Michigan versus Alexander White. Mr. White is charged with count 1, weapons, firearms, receiving and concealing, count 2, weapons carrying concealed, count 3, weapons, felony firearms, set for preliminary examination and appearances.
Alexander Kirker on behalf of the people, P 86282.
Good morning, Your Honor. Catherine O'Mara, P 53823, on behalf of Mr. White. Mr. White, please state your full name, please, for the record.
Alexander White.
Good morning. All parties ready to proceed.
The people are not the necessary witnesses have failed to appear.
We're moving for dismissal, Your Honor. Okay, I will dismiss without prejudice, time is 9:47, and we're not ready to. Should not take long for you to get your forms already signed. Thank you. You're welcome. Attorney Robinson, can you hear us?
Yes, Judge. Good morning.
Good morning, how you doing?
I'm pretty good. How are you?
Pretty good. You have Mr. Jefferson, correct?
Yes.
Are you, let's see, go back here. You want me to just call it, or are we waiting for something?
I haven't had contact with him, Judge. If you could call the case, please, if you're ready.
Okay. I'm ready. 2356079, the people of the state of Michigan versus Kevin Jefferson. Mr. Jefferson is charged with count 1, assault with a dangerous weapon, felonious assault, and count 2, weapons, felony firearms, set for a PCC today. Appearances?
Alexander Kirker on behalf of the people, P 86282.
And Sarah Robinson, P 63181 for Mr. Jefferson, who is not present. I've not had contact with him. I've called, I've sent a letter.
Okay, and this was adjourned so that you could do so and try to contact your client, correct?
Correct.
Okay, anything from the people?
The people have moved for KP.
Okay, I will issue a case, it'll be $1,000 personal.
Thank you.
You're welcome. Have a good day.
You too.
Thanks. From the record, this is the people of the state of Michigan versus Caleb Garrison, case 3555913. Mr. Garrison is charged with count 1, police officer assaulting, resisting, and obstructing, causing injury. Count 2, police officer fleeing, fourth degree vehicle code. Felony commission with motor vehicle adult advisory and set for a preliminary examination. The appearances.
Philip Henderson for the people, P86029.
Yes, Mr. Court, good morning, Your Honor. Attorney Damian Cash on behalf of Caleb Garrison, P number 85852. Please have the name for the record.
Caleb Garrison.
Is everyone ready to proceed?
Yes, yes.
Okay, any preliminary matter?
No, Your Honor. So, here to waive the preliminary exam today, but need to address just the bond issue.
Okay. Any objections to the waiver?
No, Your Honor.
Okay. So, I guess bond first before the waiver. Whenever you're ready.
Oh, I'm sorry, I didn't know if you said something too. Sorry about that.
Take your time. Get this paperwork.
So when we had the arraignment, I was under the impression that he was released on a PR bond. And then later on, I discovered that it was an extradition matter to Ohio. So just not sure where we are on the PR bond. The plan is for him to go to his family member's house, his mom's house here locally, while the matter is continuing to be addressed. And we're looking to get him over into specialty court, mental health court.
Okay, let me turn out the car away.
Okay.
Oh. Yes, ma'am. Okay, let's see what's going on. I have an updated register of action. So on the date of his arraignment, April 13th, was set at $20,000 person. And that's it. It says tether requirement imposed. That those are the only conditions I have.
So he should be able to be released on a tether, correct?
So extradition to Ohio, are they keeping him in custody until he's extradited?
I haven't received any information on that.
People know anything about that?
We don't, Your Honor. We don't know where it's at in the process of the extradition. But we have no objection on time, so it's no harm matter just to go there. The reason he fled in this case was because he knew he had the charges at the time, so. We don't have any, right, the matter needs to be dealt with. We don't have any information on where that's at in the process, Your Honor.
So, I'm sorry, did you say April 13th? I'm sorry, I meant to say March. Officer Ed, did you say that it's a hold?
Yes, Your Honor. Yes, Ohio hold.
That's what it is, he's in custody for Ohio hold, so it is for the extradition. So it doesn't matter what we do, because he's extradited, so this is over with, for the same stuff.
Until our matter is over here, he says that's, okay.
To make sure that he's sent to Ohio.
Okay, is it, okay, I'll address it in circuit court first.
I didn't hear you.
I said I'll address the question I was about to ask, I'll address it in circuit.
Okay, so let's not delay, so that we can cross the street. Okay. All right, Mr. Garrison, you can stand up, please. I'm going to ask you a series of questions. If you can't understand me or if you can't hear me, please let me know, okay? And make sure you speak up for the court recording with your response. Okay. Is it your wish to waive your preliminary exam today? I can't hear you.
Yes.
Okay, if you have questions, you can ask, okay? If you understand that you have a right to a preliminary exam.
Yes.
And that if you were to demand that exam today, the people, the prosecutor at this other table would have to show at the probable cause standard, which is a much lower standard in criminal law, but still a standard, that those charges I just read off committed in the city of Detroit and that you probably committed those crimes. You understand that?
Yes.
Okay, and that by waiving your exam today, that means that people don't have to prove or show any evidence today at the probable cause standard. Okay. You also understand that you're not giving up your right to trial.
Yes.
Okay, did anyone force you or threaten you to waive your exam today?
No.
Did anyone promise you? No. Okay, I find your waiver to be really voluntarily, understandingly given. Since you're in custody, you're right on the information will be 1 week from today. That will be April 17th at 9:00 a.m. Frank Murphy Hall of Justice. Okay? And hopefully you get some more clarity as to your extradition. But there is a hold based off of your Ohio. Anything else, read the party?
Okay.
All right, I have everyone's signatures, so we're all set on the record. This is case 2355274, the people of the state of Michigan versus Brendan Lee Atkins. Charged with one count of weapons carrying concealed set for a preliminary examination. The appearances.
Philip Henderson for the people, P 86029.
Good morning, Your Honor. Good morning to your staff, neighborhood defender services, by Ken Reagan, P 82125, on behalf of Mr. Atkins.
Okay, and I don't see Mr. Atkins present. Have you had any contact with him?
Yeah, and I've spoken with my clients, about the case, I checked with him Friday, I left a voicemail, I didn't know that he was here. I have no explanation for non-appearance.
People would move for a case.
Okay, and I did speak to him on Zoom on the 21st of March, so I know he is aware of his exam date today, because I did tell him on Zoom. So I will issue a case. It'll be $2,000 cash. Non-appearance.
Thank you.
Thank you.
Have a good morning, Your Honor.
All right, we're gonna move down time, so let's. Mr. Reed, can you unmute your device, please?
Yes.
Have you talked to your lawyer?
No, ma'am.
Okay, so you have to sit here all day waiting. I'm going to adjourn your case to tomorrow. You come back tomorrow and we'll leave a message with your attorney to come back at 8:30 tomorrow.
Okay.
All right, so just zoom back in at 8:30. Try again.
Okay, thank you.
You're welcome. Have a good one.
Amen.
Okay, Attorney Armstrong, we have the file. I'm ready to call the case. Are you ready to go on the record?
Yes, Your Honor.
Okay, this is the recall, case 2356199, people of the state of Michigan versus Terrence Williams. Mr. Williams is charged with one count of robbery armed. This set at 11:32 address 5. Attorney Upshaw, do you want to restate your motion or like you just,
Yes,
okay.
Your Honor, I have the discovery in my hand and it states on March the 9th, 2023, Ms. Mitchell alleged that her and the defendant went to purchase some marijuana. She went to withdraw her money, then he pulled a knife, said, "Oh, girl, I need that cheese," and drove off. And said she didn't know him and just knew his name was TJ, took his plate and went and talked to the police. However, on March the 29th, 20 days later, the officers were driving and performed a traffic stop. It looks like Mr. Williams, he was again in the car with Selena Mitchell on March the 29th. And at that point, they arrested him on this offense. Judge, I'm just asking that you know, what sense does it make that a woman with no witnesses alleged that he took her money, he drove her to the thing, and then 20 days later, they're out on another date? Judge, no one was harmed. There's two sides of the story. I'm not alleged any more of the facts because I know this is just a bond hearing. So based upon that, Your Honor, I'm asking the court to consider a 5% bond.
Can you say the amount one more time, the last part of your audio now? Did you say 5,000, 10%?
Yes, Your Honor.
Okay, Mr. Kirker?
At this time, we were able to review both the investigator's report and we were able to speak with the officer in charge regarding the second incident. And based on that conversation about what happened in the second incident, we would still ask that bond remain the same and continue to insist on no contact with the victim.
Okay, so a bond redetermination hearing was held on April 4th with Judge Mechanico, and the bond was lowered to 50,000, 10%. What I will do, I will order a DSU report at this time. And see if there's any reason to change the bond, since Judge Mechanico already heard the facts and made a decision a week ago.
Well, Judge, two things. I was the attorney of record a week ago. It was Phil Reagan came in a week ago. He didn't know the situation here with Miss Mitchell. They didn't argue the fact that they were together. And Judge, usually on a robbery, you're thinking of someone is charged with a robbery armed. That's a predatory offense. He's out looking to rob someone. And on this case, Judge, when you start thinking about recidivism and things occurring and of being a predator, how can you say you're a predator as an armed robber when you and the young lady, she didn't even allege that he touched or hit her or anything of that nature. And now 3 days later, they still dating, they're going out. Judge, with all respect, I appreciate and respect any decision you make. But I was just trying to think that based upon those unique set of facts, that some other bond other than the $50,000 bond is more than reasonable. I mean, that's excessive on these facts. They're together out dating. She was just mad at him about, I'm not going to say why she was mad at him, but obviously it's not an armed robbery. Obviously she's not afraid. Obviously she's still going over his house and dating him. And obviously he never stands on her.
Okay, Attorney Upshaw, one other thing option, I'll move the exam date up to next week until, so that you won't be in custody and order DSU.
Okay, what's the earliest date?
So we have now the 27th, we had someone just adjourn the case, we have the 18th at 9 o'clock and the 19th at 9 o'clock.
1 second, please.
Okay.
Get it from my baby.
Sorry for the long delay, Your Honor. I had left my book. Your Honor, you would have anything in the afternoon on the 18th, would you?
We can do the afternoon, he's in custody, I make it work.
Okay, thank you.
So let's do 18th at 1:30 and I'll order a DSU report.
You have a wonderful day, Your Honor, and thank you.
Thank you too. Okay, never mind. He might be accessible. He's not on the list, unless he's David Lewis. The bond form says.
You know, I know you need a birthday. Thank you so much. All right.
Right. Oh, good. The person with the phone number 802-7788, can you state your name, please?
Curtis Tatum.
Taylor?
Tatum. Tatum.
And what are you calling in for, sir?
When I was reading on this paper right here, it's telling me it's saying I have been granted release pending resolution of the above case, and then it's saying call or pretrial services within 24 hours, or am I supposed to call within 24 hours before the pretrial?
What type of case is it?
It don't say no case on here.
What type of case are you here for? Is it a felony, a landlord tenant, traffic,
No, it's a felony.
a felony?
Yeah.
Okay. Spell your first name.
Curtis.
Tatum, Tatum?
Yeah.
So his case is on the 14th of, I'm sorry, his case is on the 14th in front of you, same courtroom at 8:30.
Okay, Mr. Tatum, you're just a little early. Come back
Okay.
on Friday, 8:30 on Zoom, just like you did today.
At 8:30 in the morning on Friday.
Yes, sir.
Okay, that's Friday. It's the 14th.
Yes.
Okay. No, I just thought it said call within 24 hours, but then I just looked at it, and I guess that's saying call within 24 hours of the pretrial. But you say just call back Friday.
Friday at 8:30 on Zoom, just like you did call in today.
Okay. So just call back Friday. Okay.
All right, I
Okay.
love you all.
Can I ask you one more question?
Sure.
How do I find out about getting my vehicle out the impound?
That's what you have to talk to your attorney about that at this point. The court can't help you until we actually have your hearings.
Huh?
You have to talk to your attorney about that at this point.
Okay, so when can I call him? I can call him today?
Yes, you can.
How do I get his number?
Okay, you know what? All right, call the court. We're in the middle of getting ready to hold a preliminary examination, and you need some help. So call this number. Let me know when you're ready.
Okay, hold on 1 second. Okay, I'm ready.
313-965. 2406.
2406.
Yes, the clerk is waiting for you to call.
Huh?
The clerk is waiting for you to call.
Okay.
All right, bye.
Bye.
Why were you actually? You have mental illness. How do you do? Just tell me what you want to do. Look, I don't know. You don't. Look, I'll move this.
Ready, Judge, let's go.
Okay. This is people of the state of Michigan versus Christopher Harris, case 2355957. Harris is charged with count 1, assault with intent to murder. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3, weapons, firearms, possession by a felon. Count 4, assault with a dangerous weapon, felonious assault. Count 5, weapons, felony firearm. Count 6, 7, 8, also weapons, felony firearm with a habitual offender second offense notice. Also, people of the state of Michigan versus Christopher Moore, AKA Christopher Reuben Moore, AKA Christopher Reuben Harris, AKA Christopher Reuben Moore, spelled different. Case 2159420. Charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, weapons, firearms, possession by a felon. Count 3, weapons carrying concealed. Counts 4 and 5, weapons, felony firearm with a habitual offender second offense notice. Both cases set for preliminary examination and appearances.
Lauren, accepting Your Honor, E67104.
Good morning, Your Honor. Mark Magnuson on behalf of Mr. Moore on both cases, although in one case he's identified as Mr. Harris, but he advises me he's actually Christopher.
Okay.
Ready to proceed, Your Honor? If there's more than one witness, I guess we're doing the case known as Christopher Harris first. If there's more than one witness, I would suggest that there be some question.
Your Honor, if people would join in a mutual order of sequestration with the exception for the officer in charge, that would be Officer Jacob Schmidt, who is present in the courtroom at this time.
Any objection?
No objection.
Okay, so you're starting with the 2023 case, the most recent case first?
That's correct, Judge. And I do, prior to starting the exam, I do want to amend the information to also include the alias of Eric Smith.
Okay.
Judge, if people are ready to proceed. Judge, is there sharing capabilities via Zoom?
Yes.
Thank you, Judge. Then I will have to utilize Zoom and share the screen at one point.
Okay. So if there's anyone on YouTube or on Zoom who was watching and may be a witness on this case, now's your time to log off. As far as in the courtroom in person, with staff, attorneys, and Mr. Moore present, and the OIC. With that, call your first witness.
Thank you, Judge. Prior to calling my first witness, people would move to admit pursuant to MCL 76611B for the purposes of prior record, defend a register of actions sealed by the court and under the name of Christopher Reuben Moore. And that would be that on February 19th, 2003, the defendant was sentenced to your probation for receiving concealing property 1,000 or more, but less than $20,000. That would be an attempt. Furthermore, that would be People's Proposed Exhibit 1. People's Proposed Exhibit 2 would also be a certified copy of the defendant's prior conviction out of Ohio, Richland County, Ohio. People moved to admit pursuant to MCL 76611B. Defendant was convicted on October 1st, 2014 of weapons under disability, which is classified as a third-degree felony. That would be People's Proposed Exhibit number 2.
Okay, have the defense counsel an opportunity to review the documents?
I have, Your Honor. I've looked at the appears to be certified copies of those documents. I'll leave it to the discretion of the court.
Okay, well, for exam purposes, it's allowed.
Thank you, Judge. May I publish the report?
Sure. And I will admit as exhibits 1 and 2, as stated, they say they're set in on the record. Anything else?
No, at this time, people would call Mr. Pierre Smith, Your Honor.
judge.
Court reporter first, then I'll screen. Raise your right hand. You swear to tell the truth, no truth, and nothing but the truth. Okay, so the door opens up right here below you. Once you have to speak. Best thing to do is hold that microphone right there in your lap, make sure you speak up in it.
Mr. Smith, can you please state your name for the record?
Pierre Smith.
Thank you, sir. I'm going to take you back to March 30th, 2022. I know it's been a while. Did something happen that day that brings you to court?
Yes.
Were you at an Amoco gas station on that day?
Yes.
All right, and were you driving a red Camaro on that day?
Yes.
Okay. And was that gas station at 9657 Gratiot Avenue in the city of Detroit, County of Wayne, state of Michigan?
Yes.
All right. And what were you doing at that gas station, sir? Well, can you tell me, like, did you go there to get something?
Yes, I went there to get some groceries.
Okay.
I was going to get it for that next morning.
All right. Was that groceries for your family, sir?
Yes.
All right. And did you go there alone or with someone?
I went there with a friend.
All right. And were you driving that red Camaro that day?
Yes.
Do you recall what you were wearing that day?
Yes, I was wearing black, sort of like what I got on, but with some like pictures on it.
Okay, so you're wearing black, and what color were the pictures, sir?
It was like blue, gray, red, yellow.
Okay, all right, and was your friend seated in the passenger seat when you were driving?
Yes.
All right, and did something happen, when you got to that gas station?
Yes, we had got into a disagreement.
You and your friend?
Yes.
All right, and where did that disagreement occur? Was it inside the vehicle or outside the vehicle?
It was inside the vehicle.
All right, and what happened when you had that disagreement with your friend?
He wanted me to take him somewhere, and then since my vehicle was a nice, something nice to me, and I work hard for it, I told him I didn't want to go there. And he's like, well, no, whatever. So that's when I was like, well, let me go in the store and get more. I gotta get my items. And some guy said something to me in the store that made me mad. And that's when I walked out. And
Let's slow down, because I see our court reporter is, you're going a little fast, and we need to slow down for her, okay?
Okay.
All right, so the friend that you went with, you had an argument with him in the car, and then is that when you went inside the store?
Yes.
Okay, would that be the store inside the gas station?
Yes.
All right, did you actually purchase the items that you
No.
needed to get?
I didn't get a chance to.
Okay, why is that?
Because I noticed my friend was getting out of the car, and I'm like, what are you doing? You roll with me, so I don't want the one saying that, saying you coming up, something happening, but they seen you when we last.
Okay.
So that was like, no, I'm getting out. So that's when he went to the bus stop.
All right, and when your friend went to the bus stop, what did you do?
So when my friend went to the bus stop, I was like, just take this money and then get it. He was like, no, I don't want it. So I threw it on the ground. When I threw it on the ground, he was like, no, I don't want it. So someone came and picked him up. As I turned around and looked at the car and came and got him, I looked on the ground and tried to see where my money was.
All right, and so you threw the money at your friend?
Yeah, I threw it to cut him to get on the bus to go home because he wasn't going to get in the car.
Okay, and then who picked up that money? Now, let me ask you, was it cash?
Yeah, it was cash.
Okay, all right, and who picked up the cash?
The gunman.
All right, now, did you know this person you now described as the gunman?
No, I did not know this person.
So was your beef this entire time with your friend?
Yeah, it was my friend, and it was all about safety. That's the whole thing. The key was about safety. I mean, he wasn't here when I was coming from, so I at least try to the money I knew I was going to use to get my kids some food, whatever. But his safety matters. I know the food, kids, so I said, take the money.
Okay.
And he's like, no, I don't want it. I don't want it. Give it to them. Give it to them. And I was like, no. And then as we noticed, some car pull up. He get in it. And I say my last words, and by the time I turn around, that's when I noticed my money was missing.
Okay, and so your friend got in this car that pulled up?
Yes.
All right,
I seen him getting hurt in my mind.
okay. And this person you described as the shooter, where was this person?
He was in the bus stop, sitting on the right side of the bus stop. So all on the left side towards downtown, there was somebody sitting that way. He was like sitting going towards 8 Mile away. So
Okay,
on my right side.
all right. And this person, you'd already said you don't even know.
I didn't even know him. He
All
was
right.
just watching the situation. Then he saw a vulnerable moment and he went for it.
All right, did you see him take your money?
No, I did not actually see him take my money.
Okay. And, all right, did you have any interaction with this person?
No, I had a reaction to a person until some person was at the bus stop, because it was more than people at the bus stop, wasn't he? That's when he told and said, bought something from him.
All right, and did you buy anything from this
No,
guy?
I didn't buy anything. That was the person was at the bus stop, because it was multiple people there. It wasn't just us.
Okay. And did the person you labeled as the gunman do anything at that point?
Yeah, I approached him as a marvel. The good way said, hey, can you give me my stuff back? He told me I didn't want, no, I'm not giving it back to you.
All right, is this the cash that you?
I didn't hear. You said you approached the gunman and asked him to give you your what?
My money back.
My money back.
All right, and did he give you your money back?
No.
What happened then?
So as that was at that point was as I was going back to the car, going to the trunk to get my charger, because my phone about to die, and I went to my car to make sure I had my keys in my pocket. I seen them transfer, him and some other guy transfer something back, and I went back over there, and I'm like, what did you give him? And he said, I gave him some, well, I don't know how to say it, some marijuana or whatever, and I tried to tell him like, well, give me my money back. So the other dude was like, well, I'll give you back 10, and he was like, I didn't give you back nothing.
All right.
So that's when I reached in, I said, okay. I thought at that moment, and I hit him.
All right. Now, did you ever have a weapon in your hand?
No weapon.
All right. Did you ever have anything in your hand?
I had nothing in my hand on my phone.
Okay. And why did you have your phone?
Because I was going to record that moment of
Okay.
my personal protection.
All right. Were you worried about your safety, sir?
I was worried about mine at that moment, as my friend left me there, it was on me, I'm on my own. Yes, I was worried about my own.
Okay. And when you punched this person, what did that person do?
He put out a gun and shot me
All right.
4 times.
You shot you 4 times?
Yeah, twice in my stomach and twice when I was walking away.
And where did he shoot you, sir?
He shot me in my arm, and he shot me in my stomach, and he shot me in my leg.
Okay. And do you have injuries? Did you have lasting injuries that have altered your life as a result?
Yes, it's art to my life. It ruined my life.
Can you tell me in what way? What are the lasting effects of those gunshots to your body?
Well, the most one that keep giving me my main problem is my right arm, and I can't do nothing. If I touch a limb on it, it's like the nerves pinch, like you getting pinched constantly. Nobody let me go, so I can't brush it.
All right.
And then on top of that, my stomach, I can't eat a lot. I gotta have a saucer size plate, because if I try to eat a big plate, I gotta come back up.
All right. And now you stated that that gunman said he's not gonna give you anything back when you asked him about your money?
Yes.
All right. And when you were shot by this person, what did you do then?
As I was shot, I went to the ground and it went black for me.
Okay.
And then I just woke up at home.
Okay.
I don't know how I got there. I just know when the last place I remember is being at that bus stop on the ground, just gone when he first shot me. And I wake up and I'm at home on the couch and paramedics came, but I was already in gone.
All right.
I don't know if I came back or whatever, but I just know the last thing I saw was my family and the time and I came back 11:59. That's when I actually reached that home.
Okay. Can I have a moment, Judge? Yeah. So I just asked you a question, sir. Your vehicle, and that bus stop, how close were they to each other? Were they in the same area, same vicinity as the gas station?
It was the same area, but it was like from that exit to where I'm standing right now.
Okay. Judge, at this time, I'd like to be able to, I'm going to log into Zoom and so I can share video.
Sure. Can you, for the record, you're talking about the exit sign?
Yeah.
The courthouse, the courtroom?
Yes. Just the distance from where
Where
I
you
was
sitting
from the
down
car
to-
to the car. Yes.
Would you say 25 feet?
Yes. The people will stipulate the 25.
Let's go, Judge.
Okay. Co-host status to share video.
Thank you, Judge. Judge, I signed in.
I can have a moment, but I'm having a little bit of trouble.
Calling you the backup. I'm having a little bit of trouble sharing
From
from
evidence.com. I'm having trouble. Pulling up everything. Oh, there it is. Okay.
Got it.
Okay. Okay. So,
sir,
I have, display on the screen is right now
the
still of the video. Do you recognize what that is?
Yes.
All right. Do you recognize that location?
Yes.
All right, what is that location?
That's Gratiot.
That's Gratiot. Is that the location where you were shot, sir?
Yes.
All right.
People will move to admit people's proposed exhibit number 3.
And
that would be camera 25, Karen 2207 224B.
No objection.
Thank you.
It'll be admitted as people's exhibit 3.
Thank you.
For the purpose of judicial economy, I'm going to move this to
starting at 10:12.
Sir, I'm going to direct your attention to the screen. I'm going to try to move up so we can see this a little bit better.
Okay.
Who is that reaching into the vehicle at this time?
Okay. All right.
Now.
Okay. And do you see the bus stop on that screen?
Yes.
All right. And can you tell me
the shooter that you described, that shooter
seat
there at that bus stop at this time?
Sitting right there where that other guy, the small guy right there at the bus stop.
Okay. I'm going to
for purposes of judicial economy, I'm now going to move
on to minute 24. Starting at 23:58. Now, a black vehicle is now leaving the screen. Can you describe whose vehicle that is?
That's my friend getting into the car.
All right.
That's when I was telling her.
Can you just, I'm sorry, can you repeat that?
That's when I turned around, what I said, that's why when I turned back around, that's when I noticed it was gone. I was looking faced at that black car. That's how I know nobody money or they definitely snatched it.
All right, and then at this time, are you at the bus stop?
No.
Okay.
I
can't understand what you're saying, sir.
My somewhere standing right there at the little dark spot, right there.
When you say that dark spot, can you describe to us what you're talking about?
All right, you see where that light that just went past? That's right there before that car doesn't go, like right there, see?
Yep. All right, when I see that you have gone into your vehicle, what are you doing at this time?
I went and make sure I had all my personal belongings on me, so I make sure everything was on me.
Okay, why is that?
Because at that time once he got out of the car, I left my keys in.
Okay.
And I went back and grabbed them.
Okay. Now, I'm going to draw your attention to the screen. Is that when you punch the gunman?
Yeah.
Okay. Can you tell me what's happening now at this point?
When I already got shot.
Okay. And did you drive yourself home?
I remember just being on the ground telling him to stop shooting. I don't remember nothing.
Okay. I'm gonna rewind briefly. I'm gonna go back to. It's 24:59. And did you see where the gunman ran out to?
Yes, he ran towards the chicken place.
Okay, would that have been across the street?
Yes,
You see that in the screen?
yes.
And now stopping the video at 25:37. People have no further questions for this witness, Judge. I will stop sharing.
Good morning, Mr. Smith. Good morning. Just gonna ask you a few questions this morning. If you don't understand or hear me, just ask me to repeat it, fair enough?
Sure.
Okay. So I see it was dark, when you went there. Do you know what time of night that was?
What time of night?
Yeah, it was, well, let me ask you this. Do you remember the time that you went to that Amoco gas station?
Yeah, it had to be around like 11:29, 11 something, 11:17. It was right there because when I got home and when I actually got back to conscious, I looked at the time and it was 11:59. So it had to be like 11:17 or somewhere right in that area.
How far did you live from the gas station?
Objection relevant. Respond.
Trying to get a time of when this occurred, and I'm trying to get it, lived, in, Ferndale versus, East Point. I don't know. They were not asking for an address. Just asking how far away you lived from the gas station.
I'm gonna allow it for the timeline to establish. Very well.
I'm saying like,
Without giving your address.
okay. I'm like, 15,
About 15 minutes away or 50 miles?
like, yeah, I like 7. I want to say like 7 minutes away.
7 minutes away.
Yeah.
And you came with a friend of yours who wanted to go someplace in a dangerous neighborhood, and you're not taking your ride over there. Is that correct?
Correct.
Okay. And so then you had a disagreement over that.
Yes.
Did the disagreement actually wind up in like, this,
No, because it's like, we grew up together.
Okay.
And it was worried more about my safety than his too, at the same time, because I am the designated driver, and I got this cool fancy car, and it's late at night. I just wanted to just go home.
And you said your disagreement were you guys, drinking or doing anything,
No.
drugs, taking any drugs or anything? Okay. So you were totally, sober, no, you hadn't ingested any type of,
At that moment, I couldn't tell you what we were tested, but I know I was totally in my correct mind. Because I know that we get like, our kind of get control substances, you know what I'm saying? Like, legal substances that's out here in the dispensary. We had that in us, but we didn't like drive with it, nothing like that,
So you would purchase some, dispensary?
No, we didn't purchase anything that night. No, it wasn't even anything like this. Like I picked them up and when I picked them up, we went straight to the gas station.
All right, so when you look at your blood work from when you went to the hospital, there's gonna be no.
I wouldn't know that for real.
Stop. Objection relevant. At this time, the witness has already stated that he had nothing that was altering his mind, so I'm objecting to any further questions.
Well, he seemed equivocal, Judge, and I simply asked him, whether or not if there's anything gonna be revealed in the blood work that.
But I wanna ask a question.
No, don't say anything yet, okay, gotta wait for a question.
It would be improper impeachment. The defense is not using anything to impeach him, but he's trying to impeach him.
Asking a question of whether or not he has had anything that could possibly affect his perception in this matter.
And he said that, if I'm not mistaken, you said that you did consume something that was legal, that you got from the dispensary?
No, he was asking me of that day, but it wasn't at that time frame, no. That's what I was trying to tell him. In that part of the day, like when I first woke up or whatever, but that time frame, I was in my correct mind.
Okay. So he's answering that he did not consume anything.
Within the past 24 hours?
You know what I'm saying? That incident, I didn't assume anything. That could have been in my blood work from the beginning, and it stayed there. You know what I'm saying? But I was in my right mind, as I told you the whole story. I was physically there.
So then your friend went over to the bus stop because he wanted to go to that place, we call it the bad place, right?
Right.
And so he was initially going to take a bus, right?
Right.
And then you decided at some point, well, just take this money, and you threw some money at it, right?
Right, threw it towards the ground like this.
Well, you went in his direction.
Right.
Okay, and he says, I don't want that money, or words to that effect. Okay, do you remember how much money that was?
It was $40.
$40. And is that the cost of a bus ride, do you know?
I don't want to know.
Okay.
I just wanted, at his safety, I just wanted to give him something to get here and there.
Right, and so, was it like 220s or?
Yeah, it was 220s.
All right, and he's not taking it. But in the meantime,
he got in the car and pulled off. That's when I started yelling at him. I said, "What are you doing?" That's when I turned back around and tried to pick my money. It was gone.
did you know who was the car that was? Was this another?
It was his brother.
Brother, okay. So he drove off with his brother to the other place. Okay, so then now you know the money is gone, right?
Correct.
And there's like 2 or 3 people in the in that bus stop.
Yes.
And you figured that money just didn't blow away. One of those 3.
Right. I was kindly asking.
One of those people might have grabbed your money.
I was asking. I didn't expect to. I didn't know it could have blew away.
Right.
So I was kindly asking.
Right, and so nobody.
Just somebody did speak.
Pardon me?
They did speak. They spoke and told me.
They told you what?
Him and the government told me.
I'm sorry, what?
They both told me. The government was trading me with the person that was at the bus stop.
Okay.
They was trading. They was doing the trade.
Okay,
and he
did you
told me,
see them exchange?
Yeah, I seen them exchange.
All them with the $20 bills?
Like, here you go, here you go.
Okay, they're kind of dividing dividing up the
Right, and
loot.
then the person that exchanged one, he said, I will give you back 10.
Yeah.
And the gunman said, I ain't giving you back
I'm not
nothing.
getting you back in and man, you,
Right.
the way you abandoned it, whatever.
Right, I didn't abandon it, it was right behind me. It just
Yeah. Okay.
happened to grab it on from behind me.
Right, so then you decided to take things into your own, hands here. You confronted the, guy saying, give me back my money. And the next thing, even though you had no weapon, you punched him.
Yes.
Okay, you didn't call the police or anything?
No, because he showed me his weapon, and I thought at that moment, at the time, I was already, he was gonna use it anyway.
Might as well hit him.
Yeah.
Okay.
So when he went back, that's when I tried to go forward towards my car, but I got
Okay.
hit before I made it.
All right, so how many times did you hit him and would you hit him?
I only hit him once.
What, did you hit him in the, like, face?
I didn't want to know. I just know I just swung and then whatever, and he just backed up and started shooting.
Okay. So he actually, you said lifted up his, shirt or something?
And he just showed me that he had, I don't know how he just was like, huh, and I'm like, what that supposed to mean? I'm supposed to be scared.
Was it in his pocket or his
It
waistband?
was like, I don't know how he just showed me.
Showed you.
I don't know how he lived it. I couldn't even go back to that moment because I tried to forget. But I don't understand. Like, it's terrifying.
Yeah.
I still shake in my sleep.
Okay.
I tried to.
But at that time, showing you the weapon didn't deter you. You hit him anyhow.
You did.
Okay. And then, you, were running back to the car and he shot you.
No, it was before. He shot me already.
Okay.
When he first shot me, I was gone. I don't remember nothing after that.
Okay.
I don't even know how I got home. That's what I'm saying. But I came back to focus and after my adrenaline, whatever calmed down, I came back on the couch.
All right. And, you went home.
I went straight home.
You didn't go to the police station.
I was dying.
You didn't go to the hospital.
I was dying.
Okay. You know how far St. John Hospital was?
I was dying.
Okay. So you decided to go home.
That's the only place I could feel that my family know I was safe and they know I was there.
Okay.
It was only like 7 minutes. I only had like, what?
Was there anybody?
35 minutes into the adrenaline, probably. I don't know how long it lasted.
Was there anybody home to call the police or call somebody?
My family.
So somebody, when you got home, they called the,
My wife.
Okay, so you went home and then somebody called.
I went home. They said I got there, I rang the doorbell. And I went upstairs, they said, and I came down, but I remember just going to the couch and just looking at the time.
Okay. And, did you, later, give a statement to the police?
I want to know I was already sedated or sedated.
Did you give a statement to the police on April 2nd of 2022?
Yes, I did.
Okay. Did you describe the man that allegedly shot you?
Yes. I described what I saw, what I think I saw.
Okay. Did you describe him as having a beard?
Yes.
Did you describe him as being tall?
Yes. My mouth getting dry.
Did you drink water?
Cotton.
Describe him. Describe him as having dark skin.
Yes.
Did you describe his beard looking like Rick Ross?
I don't remember. I don't know what that was. I don't even know what that is.
Okay.
I don't know where Rick Ross came and told me about my life or what I talked about Rick Ross.
You know who Rick Ross is?
The rapper.
Right.
Yeah.
You know what his beard looks like?
I mean, I don't look at it as a rapper. I'm trying to
I can't
remember.
understand what you're saying. I don't look at, you said I don't look at rappers.
Yeah, I don't look at like the features of their face. I just listen to their music. I don't really know. Like you asked me something that happened a year ago and I got shot and traumatized and I completely deleted it out of my brain myself, not thinking about it. He telling me to go back there and find it that had me more traumatized. It just traumatized and I'm like, I wouldn't know what to do. Like Can't not do nothing, I can't play boxing anymore, can't do
Okay,
anything.
sir, I'm not asking a question at this point. So,
You give me what you ask.
may I approach him to show him his statement?
I you know my state, I don't even remember, all I know is I just picked the man down and wrote my name down. That's all I remember. That's, I don't even know about giving, they was like, is this the man? I said, yes, that's the man. And I
Yes.
wrote my name under it and then I walked out the building. That was it. He didn't
Yes.
ask me nothing else.
Let's see if this refreshes your recollection at all, sir. If it doesn't, it doesn't. See if you can, first of all, you remember signing that at the bottom of the page?
That's not even my hand, right?
Okay, so this isn't your statement.
No.
All right, you want to take a look at it?
Yeah.
All right, you can read the whole thing if you want, but I'm referring to what's on.
Feel like they asked me something when I was in Luton, because this don't even look like my hand.
Okay, so that's.
I don't even know who this is. I don't remember nothing saying that. It's like somebody wrote it down for me
Yeah.
and they were telling me.
So they got it all wrong?
Yeah.
Okay.
I don't remember nothing.
Sure, that's fine.
Oh, you snatched out my hand, like, you ain't even that time that bill.
Okay. So, but if somebody wrote down, the beard looks like. So if somebody wrote down on this paper, the beard looks like Rick Ross, that would have been.
Can you tell me what date that was?
The date of that was, this paper is dated April 2nd, 2022 at approximately 11:07 a.m.
I got shot, March 31st. I was under, I don't know what, April, 22, April 2nd, yeah.
April 2nd.
I was the dude, I don't know what I told that man. I was actually wounded.
Okay, all right.
So I was on anesthesia, I was on a whole lot of medicine.
I'm asking you.
So I wouldn't know what I told him. I was on a lot of pressure.
So at this point, do you have any independent recollection of what the man looked like that shot you?
Yeah, I'm looking at him.
Looking at who?
You said the man that shot me.
Well, how do you know that?
How would I not know? You just showed me, they showed me the pictures when they showed me. Why would I not bring
Who
up?
showed you the pictures?
When I, the detective, when I had on I think this year.
They showed you pictures of him?
Yeah, they showed me pictures. Why would I just randomly pick someone else out the blue? I wouldn't want nobody else getting shot like I got shot over.
So they showed you the pictures and told you who it was?
Yeah, no, they didn't tell me nothing. I told them. They just showed me and laid it out on my face and I pointed them out.
Okay. How many pictures did they show you of him?
It was like at least about like 4, 5, 10, something like that, maybe 7. But I don't know what it was. I'm not gonna just randomly pick someone and throw somebody under the bus for nothing.
Yeah.
I don't want nobody else getting shot like that with $40. Took someone else trying to take my life.
So you are able to identify this man sitting here in the.
Yeah, I've been looking at him the whole time. He didn't want to look at him.
And so but you're able to identify him from the pictures that you saw.
I'm able to identify him, just I'm able to identify you with some glasses on, okay?
Okay, yeah, because you're looking at me now.
Right. So, I'm not just gonna throw nobody under the bus. That is not fair. That's under God's rules.
Okay, no, I understand. So at the time that was contemporaneous or at the time, shortly after the incident, you described the man that shot you as having a beard, as being tall and dark skin and having a beard like Rick Ross. But then when you saw the pictures that were shown to you by the police, then now you can identify him.
Now, can I tell you what? I was subdued under a lot of pressure and they were giving me a lot of narcotic medicine.
Mr. Smith, do you need to date?
Yes, no, I'm trying to get it out now. So,
It's
there's so
fine.
much pressure right now.
Take your time, slow down if you need to.
I have nothing further.
Just take your time and just answer questions as they're asking, okay?
Redirect? Yes, Judge. Prior to my turn my redirect, I am going to let the court know and defense know that people intend to add a count of armed robbery as well as armed robbery causing serious injury and corresponding felony firearm charges for both the added charges. Mr. Smith, you now stated to the defense that you see the person who shot you in the courtroom.
Yes,
Where is that person, sir?
standing right behind.
Can you describe what that person's wearing?
Yes, green.
Let the record reflect that the witness has identified the defendant Christopher Harris, also known as Christopher Moore, also known as Eric Smith. So reflect. Thank you, Judge.
Just for the record, we would object to any identification that was made in the proper photo line.
Noted for the record.
Thank you.
I have no further questions. Okay. Just make you sit down. You're gonna testify. I call Officer Clear at this time, Judge. Okay. Clear, CREER.
Perfect.
Judge, I know that we have a second exam, and it was brought to my attention that defense has another matter at 12:30, so I guess I kind of want to know what our plan is for the second matter, since they do have witnesses here for that.
Okay, so we have a 1:30 exam. You would have 1:30 if you have to go, come back.
I do have a meeting, a 2 or 2:30.
How long is it gonna take?
I have one, and I have this witness and an additional witness for the interrogation. For this one.
You have a matter set at 12:30.
I have a matter before Judge King, exam at 12:30. That's my legal assistant to call Judge King. I don't know what his schedule is, probably very tight like everybody else. And the only thing I can suggest is,
I'm like, wait a minute, no, that's a different case.
Yes.
We want to get, we want, don't want.
Oh, I didn't want to come back up here. I work midnights tomorrow. Tonight, I don't want to come here. But-
I just didn't want them waiting while we finish.
Oh, yeah, I got you. Appreciate it. Let me just get here and say, y'all really can't get me out now. Hold on.
I still have to swear you in.
Okay, go.
I just want to make sure.
Oh, we're good.
That works tomorrow for the second exam at 1:30.
1:30.
Okay, all right. I'll swear you in. You swear to tell the truth, and nothing but.
Yes, ma'am.
Okay, everybody, take it.
Oh.
Just releasing the judge.
Okay.
Officer Creer, can you please state your name for the record?
No problem. First name is William, last name is Creer.
Thank you, sir. And how are you employed?
I work for the City of Detroit Crime Scene Services Unit, Detroit Police Department.
Awesome, thank you. And were you working in your capacity with the Crime Services Unit, Crime Scene Services Unit on March 30th, 2022, going into March 31st, 2022?
Yes, ma'am.
Okay, and were you called to an Amical gas station at 9657 in Gratiot Avenue, Missouri, Detroit County Lane?
Yes, ma'am.
All right, and can you tell me, did you make any recoveries or take any photographs at that location? Tell me you did.
Yes, well, we went to the scene. We were met by Lieutenant Cameron, I believe, at the location.
Okay.
She pointed out evidence to be collected. We took pictures, we found additional evidence, and we took more
Judge,
pictures of the area.
I appreciate these officers in the team, but he keeps referring to we. I would just say that what he did is.
My apologies. I collected evidence while my partner took photographs of the location.
All right, and did you come to recover a black hat?
Can I look at my notes to refresh my memory, please?
Sure. Do you have a copy of those notes with you?
Yes, I
Will
do.
those notes refresh your recollection?
Yes, they will. Thank you.
And are those, you stated notes, but is what you held up, or is that actually your police report?
Yes, ma'am. It's my crime scene report.
Thank you.
According to my notes, 2 hats were collected from location. One black knit hat and one black Detroit Pistons hat.
Okay, were they given numbers?
Yes, ma'am. The knit hat was placard number 5 and the Pistons hat was placard number 6.
Okay, and would those also have been given evidence tag numbers of some sort?
Yes, ma'am. I'd have to read off the numbers kind of long for both items.
Please do,
Thank
if
you.
there's no objection. Thank you.
The knit hat is evidence tag number 22033-00404. That's going to be item number 4. And the Pistons hat will be 22033-00404. That'll be item number 5.
Thank you. Where did you locate these items?
Both items were at the Amico gas station, the bus enclosure, ma'am.
In the bus enclosure?
Yes.
Thank you. I have nothing further. I have nothing further. Ross?
I have nothing further.
Okay, you're all set.
Thank you very much.
Sorry.
This time, if people would move to, oh, all right.
Oh, shit. Thanks, bro.
At this time, people would move to admit pursuant to MCL 76611B. State of Michigan Department of State Police Biometrics and Identification Division, Lansing Forensic Laboratory, people proposed exhibit number 4. This would be a MSP lab report authored by Elizabeth Lyons, forensic scientist, CODIS section, laboratory ND 22932, record number 3. which states that DNA Database Specimen Case Association, a search of the state level of the Combined DNA Index System, CODIS database resulted in a moderate stringency association between item MD 22932 1D knit hat swabs and DNA database specimen MI 21-012215. This deemed investigative information. There was a positive hit for Christopher Reuben Moore. Well, actually, it's the DNA database specimen name, Christopher Harris, and alias Christopher Reuben Moore. Date of birth 10/28/1984.
That's counsel, defense counsel seen the report.
Well, I got a copy of my discovery, Judge. I have no objection for exam purposes only.
Okay, it will be admitted as people that did the work.
Thank you, Judge. Would you like me to publish to the court?
Yes.
At this time, I'd like to call Officer Jacob Schmidt to the stand. Okay. Oh, he's right here. Sorry.
Make sure you speak into the microphone.
Officer Schmidt, I'm gonna ask you your name for the record.
Yes, ma'am, that's first name Jacob, Jacob, last name Schmidt, Schmidt.
Thank you. Officer Schmidt, how are you employed?
I work for the city of Detroit.
Okay, and are you a police officer with the city of Detroit?
Yes, ma'am.
And were you working your capacity as a police officer with the city of Detroit on March 30th, 2022, going into March 31st, 2022?
Yes, ma'am.
All right, and were you investigating a shooting at 9657 Gratiot Avenue in the city of Detroit, County, Wayne, State of Michigan?
The case had been reassigned to me from the previous IC, yes, ma'am.
Okay, that previous OIC, would that have been Detective Marlon Binion?
That is correct.
Thank you. And did you come, at some point, come to speak with an individual related to the shooting?
Yes, ma'am.
Was that person named Christopher Harris, also known as Christopher Moore?
Yes, ma'am.
Do you see that person in the courtroom today?
I do, yes, ma'am.
Can you please identify who that person is in the courtroom and tell me what that person is wearing?
Yes, ma'am. Sitting right behind defense counsel, wearing green right now.
Okay, and let the record reflect that the witness has identified Christopher Harris, also known as Christopher Moore, also known as Hunter and Harrison. So reflected. Thank you. And did you come to at some point administer a DNA swab of this individual?
Yes, ma'am. I had two of the officers from the Special Operations Division actually conducted the swab, but a search warrant was obtained, so.
Thank you. And that would have been from the individual who identified in the courtroom?
That is correct.
Thank you. And did you at some point speak with this individual?
Yes, ma'am.
All right. And was that on March 14th, 2023?
I believe so, yes, ma'am.
All right. Did you read constitutional rights to this individual or have this person read them?
Both. So they read aloud and then he was able to review it at the time.
Okay. And I'm going to approach the witness with people's proposed exhibit number 5, which would be the constitutional rights certificate of notification. May I approach it?
Yeah.
Officer Schmidt, I've handed you a document. Can you please identify for the record what it is I've handed you?
Yes, ma'am. This is the constitutional rights certification of notification for Mr. Christopher Harris, aka Mr. Christopher Moore.
All right, and did he provide a date of birth to you?
Yes, ma'am. Date of birth is 10/28/84.
All right, and that constitutional rights, does it have, did the defendant initial each right?
Yes, ma'am, yeah,
All right, did you both, so you say that you read each right to the defendant?
that is correct.
And you also gave the defendant an opportunity to read the rights?
That is correct.
Did the defendant appear to be intoxicated in any way?
No, ma'am.
Did the defendant appear to be sleepy or in some sense, in any way, unable to understand the rights that you had allowed him to read himself as well as that you read to him?
He did not appear so.
All right, did he sign those rights in the manner such that he, was willing to speak to you?
Yes, ma'am.
All right, and at this time, I'm going to turn it over to defense for purposes of knowing and voluntariness of this statement.
Just a couple questions. Are you the officer in charge?
I am, yes, sir.
Okay, so you're familiar with the reports and so forth and file?
That is correct.
So you had contact with them on the day of this interrogation, was March 14th?
Yes, sir.
And you were aware that the day before, on March 13th, he was arrested?
Yes, sir, I was. I believe so, yes.
And you were aware that he was arrested at a facility called Team Wellness?
Yes, sir.
And that's located on Mack Avenue, is that correct?
That is correct.
And that's a mental health facility?
Yes, it does have a mental health capacity to it, yes, sir.
Right, so people go there to get treated or examined for mental health problems.
I believe so, yes, sir.
Okay. And they also can maybe pick up the medication for medication.
That is correct.
Okay. And so knowing this, did you, prior to interrogating him and having him execute this constitutional rights certification, did you have an opportunity to examine his mental health records or subpoena or get any of those records from mental health facility that Team Wellness has?
I didn't obtain any medical records or history for the individual.
Okay. So, did you have any concern about his mental health?
I did not. I remember asking him, especially during the constitutional rights, if he had completed any education as well, to which he said he completed 12th grade.
Right. No, I understand that, but you can have a PhD and still be mentally ill or not competent to understand certain things. So did you explore that mental health aspect of him after having been alerted he was arrested at a mental health facility?
Nothing flagged for me to search for that at the time, no, sir.
Okay. I don't have anything for you at this time.
Did you then have an opportunity to ask him some questions about the shooting at the Amoco gas station on Gratiot Avenue at 9657 Gratiot Avenue?
Yes, ma'am, I did.
All right, and was this video recorded?
It was, yes, ma'am.
Okay. First, people would move to admit people's proposed exhibit number 5, Your Honor, that would be the constitutional rights form.
Objection.
Okay, exhibit 5. Thank you, and then at this time, Your Honor, people will need to re-enter Zoom. Okay. Your Honor, I would ask to be allowed to share my screen. Are you in the right courtroom? Do you want? Oh, I just went to Judge Adams. Yeah. Oh,
Hmm. Oh, boy. Always takes me a minute. There. Um, there. Hmm. I am having a minor technical difficulty. So I'm gonna leave the meeting.
We're back on the record.
Thank you. While we work on the video, I'm gonna ask the officer some questions. Detective or Officer Schmidt, so did you ask the defendant seated here about the shooting at 9657 Gratiot Avenue in the city of Detroit, County Lane?
Yes, ma'am.
All right. And let me also ask you, what name did he want to go by on that day?
I'm sorry.
What name did he choose to go by that day?
I believe Christopher Harris.
Okay.
I'm sorry, my apologies. I believe he said Christopher Moore, this particular.
All right. And do you know him by other names?
Yes, ma'am.
What are the other names?
Christopher Harris and then Eric Smith.
Okay. And did you ask the defendant about the shooting?
I did, yes, ma'am.
And did the defendant think that he was at that Amoco gas station at 9657 Gratiot Avenue on March 30th, 2022?
Yes, ma'am.
And did he also state to you that he shot an individual?
Yes, ma'am.
Did he give you a reason why?
I believe it was during a struggle, he ended up shooting the victim. Or
Okay.
victims, I should say.
All right. And did he indicate that he shot a number of people?
Yes, ma'am.
All right. And did he indicate to you whether or anyone else had any weapons?
No, not at all.
All right. And he himself placed himself at that location, 9657 Gratiot Avenue?
Yes, ma'am.
All right. I have nothing further. Ross?
I have no questions at this time, Judge.
Thank you.
Judge, at this time, people would publish to the court People's Exhibit number 5. Okay. People had no further witnesses, Your Honor.
Okay, none from defense?
Nothing from the defense.
Okay.
You're ready for it. At this time, the people would move to bind over on all counts, including the added counts of armed robbery and armed robbery causing serious injury, as the court heard from the complaining witness, Mr. Pierre Smith, and strike that. People would also add additional counts of felony firearm and felony firearm again for both of those felonies of robbery and armed robbery as well as armed robbery causing serious injury. The court heard testimony from Pierre Smith that on March 30th, 2022, he was at that location with his friend. They had driven there in his red Camaro and had gotten into an argument about where to go next. His friend then went to the bus stop where Mr. Smith, who gave him some money, threw some money at him so that to ensure that he would get on that bus and be safe and leave. In the course of his argument with his friend, the defendant seemingly and did pick up the money that was thrown at the complaining witness's friend. When the complaining witness approached him about the money, he refused to give it to him. Not that he didn't have it, but that he refused to give it to him. In fact, a second individual who was at that bus stop offered him to give the victim back $10, but the defendant refused to give him back anything. The victim punches the defendant with his fist, does not have a weapon, does not ever indicate that he ever had a weapon. He stated, in fact, the only thing in his hand was his cell phone. The court has an opportunity to view the video. In fact, views the complaining witness, Mr. Smith, next to his car, getting out of his car, also going back into his car to put his personal items away, as well as recover his car keys once his friend has left in that black vehicle, which was driven by his friend. All we see in Mr. Smith's hand is his cell phone or empty-handed. We see Mr. Smith punch the shooter once. So on video, we see it only once. But what then happens is the defendant returns with fire. He shoots him 4 times. Those shots take effect 4 times on the victim's body, on Pierre Smith's body, in his arm as well as in his abdomen. He states that he's unable to use his arm anymore. He states as a result of his injuries and the shots to his abdomen, he no longer can eat properly anymore. and that he's had lasting effects as from the injuries that he sustained as a result of the armed robbery and the shooting. We have then the CODIS hit of a hat that is recovered at the scene, DNA taken from the defendant and compared to the hat that was recovered at the scene that matches the defendant seated here today. Then coupled with the interrogation in which the defendant admits to having been at that Amoco gas station and having shot at an individual. So, Your Honor, at this time, the people believe that the evidence that by probable cause standard indicates that this defendant did commit these crimes on March 30th, 2022 at the Amoco gas station.
Judge, first of all, we would object to any additional counts being added. It's already track 8 count indictment or information. They're claiming now there's an armed robbery. This armed robbery caused injury, and the fact is, we heard the testimony. The gentleman threw 220s at the ground around 12 o'clock at night at a bus stop in Detroit, and there was a number of people in the bus stop. He doesn't say that Mr. didn't see Mr. Moore, Mr. Harris pick it up. He abandoned his money. This is dispose of money. This is not a situation where it comes up and says, "Give me your money for your life." Mr. Smith suspected that the gentleman had wrongfully taken his money. Should have done what law-abiding citizen does: not take the law into their own hands, not try to confront and punch him, but call the police or call the authorities and say, "This gentleman is wrongfully withholding my money that I threw away." And so, no, this is not an armed robbery. This is a situation where Mr. Smith commits a vigilante act, and he claims he referred to him as the shooter, displayed a gun, and with all their bravado, continues to pursue him and punches him. And what would somebody think when you just shown him a gun? Mr. Moore, Mr. Harris would have probably thought, "This guy's still coming at me. He must be packing too." So no, this was not an armed robbery. This is not an armed robbery causing injury. Maybe other things, but that's not a proper time. As to the assault with intent to murder, Mr. Smith was already an angry young man. He already got into an altercation with his friend. He was angry about it. He was throwing his money. He's now angry. He's got transferred intent here. He's coming after this, appears to be a stranger here, very aggressive. And there was, assuming the facts as they're presented here, it seems to me this was a situation where you don't know the situation and somebody's acting in self-defense. There's no intent here to murder, albeit there's a number of shots. I agree with that, but my client was not the aggressor in this situation. So for those reasons, Your Honor, I would object to the amendment and object to the bind over the self-defense murder.
Yes, Your Honor. I'm going to first start with assault intent with intent to murder. The court had the opportunity to review the video. In fact, I played the shooting twice. What we see is, well, first, there's no indication, and by the victim's testimony, by Pierre Smith's testimony, he never had a weapon. And defense is not even alleging that Pierre Smith had a weapon. He punched the defendant. He punched the defendant once. He stated that even before we even played the video. The video corroborates Mr. Smith's testimony almost exactly. It's important to note that Mr. Smith testified prior to the people even playing the video. And what we see is Mr. Smith is upset. He's upset with his friend. They're obviously having an argument, and Mr. Smith had thrown the money at him to ensure that he gets on the bus and gets home safely. But then when his friend doesn't pick it up, he's upset and tries to get the money back. He demands the money back, and that is no one's money but his own or the friend to whom he was trying to give it to. And Mr. Smith demands the money. The defendant does not return the money. In fact, he holds on to it. And so Mr. Smith does touch him, and he punches him once, as the video shows. The defendant then shoots him. That is not commensurate to a punch. He has upped the ante that is not self-defense to shoot an unarmed man. Furthermore, the video indicates that the defendant is quite a few feet away from the victim prior to shooting him. So he even had the opportunity to run off, or if he didn't want to engage him in a fist fight. But what he did was take steps back and shoot at Mr. Smith. And not only did he shoot him, he shot him multiple times. The fact that he created that distance, that he moved back, he aimed his gun, and then he shot at the defendant, at Mr. Smith 4 times. And those shots even took effect at Mr. Smith 4 times. That shows the defendant's intent as to count 1, as well as the lesser of count 2 and the felonious assault of count 4. In fact, we would add that prior to shooting, as well as when he lifted his shirt to show that he had a weapon, that goes to count 4. So, Your Honor, the people believe that the testimony has proven has proven by a probable cause standard all the counts, including the added counts of armed robbery and armed robbery causing serious injury and the felony firearm counts. Okay.
I do believe people have met its burden of proof today for count 1 through 8. For count 1 with assault and intent to murder. Probable cause standards, people have to show the defendant tried to physically injure another person. In this case, shot with Mr. Smith 4 times. Second, that when the defendant committed assault, he had the ability to cause injury. Weapon gun in that case. Third, that he intends to kill. I believe in this case, circumstances show and the evidence shows that there was intent to kill. That would be a question of fact, however, for the prior fact to determine that ultimately. For count 2, that's the lesser included. Count 3, exhibits 1 and 2 were admitted to satisfy count 3. Count 4, assault with dangerous weapon, satisfied as defendant displayed the gun and also shot Mr. Smith 4 times. Counts 5, 6, 7, and 8 are the accompanying felony firearm counts. As far as counts requested to be added, starting with robbery armed, I do believe that the probable cause that people have made further proof on this count as well. As there was a question of money, the plaintiff witness, Mr. Smith, stated that he asked for his money back. Kindly asked, he took his money, and once he was approaching the defendant showed a gun, and Mr. Harris then punched the defendant. But for armed robberies, the defendant had to use force or violence, put in fear of the complainant's name. Second, the defendant did so while he was in the course of committing a larceny. So in the course of committing a larceny includes after the fact, keeping the belongings, in this case, the money, and not returning the item. As far as count 10, robbery armed causing serious injury. Serious injury here being the 4 gunshot injuries and wounds, as Mr. Smith testified, it changed his life. Also said several times, "I was dying," as he was trying to describe what was happening. And the companion, or the felony firearm charges accompanying the robbery armed and the robbery armed causing injury will be added as well. as counts 11 and 12. So, the more you bound over to Third Circuit Court for the waiting on the information, April 17th, 1 week from today, since we're in custody, with the additional 4 counts that have been added by the people. Anything else?
No, nothing else.
Okay.
You were a DSU.
I will do that.
And I would like.
Your Honor, I
Can say
will note
something?
that this.
One moment, Mr. Moore. One
This
moment.
defendant is on parole and was a parole absconder from Ohio.
Okay.
So you will just want to place that on the record.
Okay, and the DSU was already ordered on the 24th. I don't know how helpful it was, but it's been ordered.
Okay, thank you.
And Mr. Harris, Mr. Moore, do you want to speak to your attorney so he can speak?
No, I don't want him, I wanna get, he knows he working with the people, I feel like he working with the people.
Okay, well.
That made no sense, I wanna dismiss him.
Well, Mr.
Please.
Moore,
Yes.
you've been bound over, so the way that's gonna work is you go for a judge at Third Circuit, address the court there and discuss your issues with your attorney at that time, if it's still an issue. Okay?
And then I got a lot of things to say, like, all these cases.
I don't want you to say anything because it may affect your case moving forward. Okay, that's why you have an attorney. And I understand that you want to switch attorneys.
So maybe for tomorrow, we can.
Oh,
we
right,
have
we
to
have
adjourn tomorrow so we can get a competent attorney. I guess we'll.
I got something to say too. Why y'all keep calling me Christopher Harris? My name is Christopher Moore. I never use none of these names in no authority. This lady is coercing everybody she's seen. The thing say the dude 6'2". I see coercing to do all this shit though.
Okay, so you're not gonna listen to me.
I'm listening to you, man.
Calm down, first of all. I understand that you're upset, okay? And I'm not trying to railroad you, okay? I'm trying to explain to you that there's a process. Okay? If you're unhappy with your attorney, I will address that. We have a case tomorrow to handle.
In that video she showed had
Okay,
me,
so
I
you're
don't
getting into the
nothing.
content of the case.
It's like she coercing
Okay.
everything she's
So,
saying.
Mr. Moore, I can't help you
Weird.
continue to have outbursts.
I'm not having, all right, my apologies. I ain't having no outburst. I'm just saying right is right and wrong is wrong.
Judge, for tomorrow's matter, will this matter be reassigned?
I think it needs to be at this point.
Okay. Shall I call off my witnesses?
Call that,
Call
yeah.
off the witnesses?
Let's, I'll have Mr. Moore stay here. We're gonna call the Third Circuit to appoint someone, by appoint.
Okay.
And get a PC.
Sounds good. Thank you, Judge.
So Mr. Moore, just wait here, okay?
Okay, so Judge, for tomorrow, I don't need to appear at 1:30 p.m.
I will make note of that. You are.
Okay. Thank you very
Like
much. More good luck to you.
Thank you. Attorney Phelps. Good afternoon. Who's the prosecutor on that for your case?
I don't know.
Okay.
We can Shelley Green, trying to text her right now.
Okay.
Yeah.
Charlie McCain. Charlie McCain.
She was not at the PCC on this case. It was just a court prosecutor. I thought it was here. Oh.
No,
No. Okay.
just OIC, that's it.
Just OIC. I mean, if it's a dismissal. I'll see it. I think it'll hold.
You want the OIC to come in?
I got it.
Oh, she got it. She got it.
Oh, she has one.
Well, then, afternoon, Attorney Cross.
Good afternoon, Judge.
Oh, you know where the volume's down. Okay, can you hear us?
I can.
Okay, we can hear you.
Yeah, I think it was. It's different now. Maybe. because of that is in between them. Oh, I'm waiting to. This, if there says it's one, so I think on Tanner or something. I think she's on.
Rouse is on here too.
Oh, okay, well, no. Hi.
Hello.
Still not an APA though. Huh, well, we don't have witnesses.
Defendant's coming.
Oh, he was downstairs.
Yeah, I know.
Judge, is this for Christopher Moore?
This is for John Tanner.
Okay, I was spot appointed to a Christopher Moore.
Sorry. Right, 'cause you,
Hey, we got a little distracted. There's a lot going on.
I'm sorry, Attorney Cross. I put you as a prosecutor. I just switched you over to a prosecutor. Sorry. Yeah,
Okay.
I thought it said APA Sarah Cross. I said, okay. All right, so Mr. Moore is sitting in the courtroom. I don't know if you can see him. We just finished one exam that was bound over, and he requested to have a new attorney for his second exam. It was scheduled for tomorrow at 1:30. Of course, we're going to have to reschedule that so that you can have time to consult with him.
Yes.
So he's in custody, Wayne County Jail. And he has a lot that he needs to discuss with you.
Okay.
So let me call the case and figure out a timeline here, and let me put Mr. Moore on the screen. Okay, this is case 2159420, the people of the state of Michigan versus Christopher Moore, who is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, weapons, firearms, possession by a felon. Count 3, weapons carrying concealed. Counts 4 and 5, weapons, felony, firearm. It was set for an exam today, which was adjourned to tomorrow. However, Mr. Moore has requested new counsel for his exam, or for this case, and appearances.
Lauren Nersassian on behalf of people, P67104.
And Sarah Kraus, P81830, appearing on behalf of Christopher Moore.
Mr. Moore, please state your name for the record.
Name is Christopher Reuben Moore.
Okay. And Mr. Moore, Attorney Kraus has been assigned to you to represent you for the case I just called. You can also discuss with her or ask me questions, discuss what just happened on the last exam if you'd like to. She is more than competent. She will listen to what you have to say. So at this point, we are going to set, we're not doing the exam tomorrow. We're going to set a probable cause conference so you have time to consult with Attorney Kraus, okay?
On Zoom?
No, she's gonna come visit you. No. So, how much time do you need, Attorney Kraus?
Judge, for a PCC, if the people get me the discovery, I can probably make the end of this week work or early next week.
And if you're assessing any issue with sending over discovery today?
No, I'll send it over immediately.
Okay. How about Friday, Mr. Moore, yes?
She said that last time, and the lawyer that they got and came with the situation. He never got it. I'm under medication. I really don't
You
have.
mean the discovery?
He never got this situation. Like she said, she was gonna stay in the
Discovery you're talking about?
Yeah, whatever she keeps saying, she's gonna send stuff to her, and then people never get these things.
So we have a new attorney.
You know what I'm saying?
That's why we're moving into a probable cause conference, okay? So let your attorney do her job, okay?
Right.
So I'm gonna set it for this Friday. I'm trying not to delay this any longer than possible.
I won't be able to attend on Friday, Judge.
Okay.
I'm in a mandatory training Thursday and Friday.
So it's just to set a date for the exam and make sure it's covered.
That's fine.
So someone can stand in.
I'll have to the court meeting to stand in, but if there are any other attention issues.
I will wait for those issues.
Thank you.
Okay, so we're gonna set this for Friday for a probable cause conference. Attorney Cross is gonna come visit you this week, and you can discuss discovery issues. She will have discovery to go over with you when she comes to visit you. Is that correct, Attorney Cross?
It is.
Okay. And then on Friday, we'll move forward. If there are any issues that need to be put on the record, we can't do it on Friday because APA necessity isn't here. We'll do it on that Monday, okay? For now, you have Attorney Kraus, and she's going to consult with you and flush out any issues you have, okay?
With the other case, who work on other cases?
Talk to Attorney Kraus about that. If we need to, if that needs, she might take that case for, well, yes. Attorney Krause, did you get both cases or just one?
I was just given one, Judge.
Okay, so for the second case that we just bounced over, do we need to call third circuit to see if you can be appointed to that, or how do you want that case as well? I think it would make sense for you to have both.
I can take it, Judge. Who was the prior counsel?
Magnuson?
Okay. If you could give the assigned counsel office a call, I would appreciate it. They should be able to put me on it.
Okay. So if there are any motions that need to be filed, Mr. Moore, are you listening? Otherwise, I can stop talking.
I'm listening.
She can also, we're gonna get her appointed to that case as well. So it's been bound over, but it's not over, so she can address those also, those issues, okay? I need to technology, yes, no, we're on the right.
I'm just trying to see all type of weird shit going on.
Can you stop cussing too?
No,
Yeah,
okay.
just a little respect for the court. Simple. I'm trying to give you what you need based off of what you told me today. Okay? So we'll be back here at 8:30. You'll be on Zoom. You don't need to come in person. It'll just be discussed discovery and an exam day. And we'll call over to see if you can be appointed or get you appointed to the case that was found over.
Now, can I get any paperwork and all this stuff? I have no paperwork on nothing.
Mr. Moore, we will discuss that when I visit you, okay?
And Your Honor, if I may, Ms. Kraft, I just got you paper discovery. There should be 3 separate items. I will also be sending you digital.
Thank you.
Okay, thank you, Attorney Krause.
Thank you, Judge.
All right, have a good one. Okay, I'll see you on Friday, Mr. Moore.
I come here on person on Friday?
No, you'll be on Zoom. Case 2356108 from the state of Michigan versus John Collier Tanner. Mr. Tanner is charged with count 1 assault with intent to degrade bodily harm less than murder or by strangulation. Count 2 assault with a dangerous weapon, felonious assault. Count 3 domestic violence with an individual offender fourth offense notice. Set for your preliminary examination today. Appearances.
Foreigner assessing on behalf of the people standing in for the attorney of record, Shelley Green. And good afternoon, Your Honor, Neighborhood Defender Service of Detroit by Natalie Phelps, P83355, appearing on behalf of Mr. John Tanner, who's also present in the courtroom. Mr. Tanner, can you please state your name for the record?
John Paul Tanner.
Thank you.
Okay, and are the people ready to proceed today?
No, Your Honor, it doesn't appear that, it doesn't appear that we will. Your Honor, the defense will move forward from the call. I will note that the license.
Okay, the time is 1:43. If people are not ready to proceed, I will dismiss without prejudice. Mr. Tanner, your case is finished. Thank you, Judge. Already got forms filled out. To the person with the phone number 704-5335, can you please unmute your device and state your name? Yeah. Okay, we are done.